Iris Baguilat, who is from Doehle Seafront Crewing and wears a number. Speaking of hats, she wears a number of hats as well that she'll speak to us about that have to do with seafarers' welfare and protection of seafarers. Very, very importantly, we have to say thank you to her not only because she's here and to speak in her esteemed capacity, but also she paid for lunch. So if you want to say thank you to Baguilat and to Doehle Seafront Crewing for sponsoring lunch, thank you so much for your support of the program. The floor is yours. Thank you.
Thank you. Good afternoon, everyone. Yes, our funnel is the PD sign on board. I think you have been going up to some of our vessels. We are a ship-owning company as well as a manning agency. So I think some of you have been up to our vessels. It's that one with a Doehle with a PD sign. That's our ship.
You might need to hold the microphone just a bit closer.
Yes. Thank you. So it's 3 o'clock. We call it hora de peligro, so it's a deadly hour. I hope you're awake after the jet lag. It's going to be a long topic, but hopefully making it interesting for you. I also chair the Association of Licensed Manning Agency. We are around 60 plus manning agencies with deploying 175,000 seafarers. I chair it at the moment. So this is ALMA, we call it, and we were formed in 2020 as a response to the pandemic because we were all lost as to what's going to happen. One of our biggest campaigns was the prioritization of vaccination of Filipino crew, and to which we succeeded. And the crew change efforts we were doing as a group. Now I'll talk about, so that's the association, and we are young, very, very young. So I say this because not many maritime stakeholders or people in policy understand what we do as a manning agency. Even in the Philippines where seafaring is very popular. What do? We are responsible for recruiting, selecting, competent identification of a crew. We arrange a training and develop the career of the crew from the lowest rank to the topmost. In short, we are marine HR. This is our main function. We take care of our crew allotments. We take care of our crew when they are sick on board and when they get off for treatment. We provide all the benefits, arrange for their medical services, and we make sure that there's a continuing trustful relationship between the employee and the ship owner. What is seafaring to the Philippines? We put it in context because number one, seafarers remit $6.5 billion every year to the Philippines. We are 21% of the 31 billion remittances of all overseas Filipino workers. So that's a significant number because we're almost one-fourth of the total, 1/5 of all the nursing, the engineers, domestic helpers, seafarers. Seafarers would constitute 1/5 of the allotments or the revenue being sent to the Philippines. Currently, we have 265,000 Filipino seafarers deployed, and there are 400,000 families, households being supported by this number. So what is the impact? This is unquantified economic impact of shore-based sector because aside from the seafarer remittance itself, which we have not really quantified, we also take care of ancillary activities which are propelling Philippine economy. So you're talking of airlines and travel, and then you're talking of, for example, our industry manning agencies, training centers which are employing Filipinos. We have maritime schools. These are all ancillary activities surrounding seafaring, and the multiplier effects of these activities have not been quantified for us. Then we also have medical clinics, we have ship management, we also have, PPE, which is a protective equipment, and many more. These ancillary activities are here because of seafaring. Over the last 50 years, we have become the leading provider of maritime professionals and considered to be the seafaring capital of the world. I think you're aware, mostly because you visit our people on board. This is a very well-paying profession compared to what we receive locally. Our average or our basic minimum wage in Manila, for example, is about 16,000 pesos. That's $300. But our seafarer gets so much more. So what does it do? If you have officers, even ratings, receiving $1,000 compared to what his counterpart is getting locally at $300. A colleague of mine would say, it is already our contribution to growing middle class. Because for our economy to grow, as you're all aware, you cannot grow it if it's a triangle, meaning a very wide lower class, very few, just the lowest would be, the smallest percentage would be the upper class. For an economy to grow, you have to expand your middle class. And that comes with democracy and everything else that comes with a very passionate middle class. But we are not yet there. Seafaring, though, is contributing immediately because the children of the seafarers now have access to education, a better life. And they're pushing that out for the families. Many of them may or may not have children going into the profession, but definitely they're able to school their children. That's very important for our economy. And this is not something that's stated. For us, contributing like what, 265,000, 6.5 billion to over 400,000 families, immediately any seafarer employed on board is now being pushed up to a higher level of economic situation. So then his children are able to access good schools, get better education than what is publicly being offered. The ship owners in the Philippines over the span of 50 years have given more than what is basically required by law. So some of us, of course, they are insured fully as part of the cover, the PNI cover. The seafarers in the Philippines do not pay income tax of any sort. So a master receiving $14,000 a month, there is no tax on income. That is part of the recognition of Philippine government to the contribution of this sector to the Philippines. All the costs of seafarers, from even way before MLC came in play, medical, travel, accommodation expenses, everything paid for by the ship owner. That's very different to our land-based foreign workers, where they have to pay for their own deployment, everything else. The seafarers serve fairly short contracts, you're aware, 3 months, 4 months, 6 months. You cannot extend 12 months. Our land-based foreign workers do not come home in 2 years. They have to be in contract where? Dubai, wherever they are located. They are there. So your nurses in your countries are Filipinos. Some of them cannot come home in 2 years. Then also some companies, we, like ourselves, we extend health cover for the whole family. And for a country without social welfare, that's very important. You take for granted, maybe in your home countries, you go there, you get treated for free. Here, you have to pay. And this is part of the privilege we give to our families. We also offer scholarships for maritime students, which we have been doing. And we do focus on their career trainings and growth. The company takes that on. Okay, so This is just a comparison of the land-based and the sea-based sector in the Philippines. For example, for land-based, it's the employee himself paying the recruitment agency to be deployed on board, or abroad. But for sea-based, it's just the ship owner paying the manning agency. So it's a very different scheme. So where is the problem? In 1990, Philippines market share in conventional vessels, we were 34%. My reference is the Drury Maritime Report. In 1995, we were at 45%. Right now, we're at 14%. So the question of Jason, is it hurting us? Definitely. So we have a steep decline of more than 3 times in market share for merchant ships from 1995 to 2021. What are the reasons? Okay, so one by one, EMSA. You are aware, of EMSA audit issues. That is causing strain, uncertainty to the ship owners. We have red tape in government, which is a pain for many of us. We have also policymakers who do not understand that seafaring is a safety-based industry. There's risk, but we're focused on safety. They have no comprehension of that. But the biggest now is the exploitation of the seafarer compensation system and ambulance chasing. This is really the biggest nightmare we're facing. It's been happening for the past 15 years. And there's been a slow, steady, effort to get it understood by government that this is a problem. And in fact, around 2015, they managed to get it recognized in law that protection of seafarers should include securing the best possible terms and conditions of employment. And then there's a recognition by a law that was passed that some unscrupulous individuals have taken advantage of the plight of our seafarers who met an accident, illness, or death in the course of their service by exploiting the compensation system. Our seafarers have fallen prey to an unfair scheme when ambulance chasers charge exorbitant fees with a promise of huge monetary award. This is legal. This is already law. This is a declaration of policy, meaning it's already part of the law of the land, okay? Unfortunately, even the passage of this law, the ship owner-employer flight from the Philippines continues to persist. Then, what is it? Why? So you have the exploitation of the seafarer compensation system. It has a critical impact on the seafaring industry because of the reduction of our market, our market share. And then we risk losing more jobs for Filipino seafarers. IMEC was bold to say that maybe in 10 years, no more Filipino seafarers if we don't do anything about this. This is Francesco Gargiulo. He is the CEO of IMEC. He was quoted in the Philippine newspapers. Our members had decided to look elsewhere given it was practically impossible to win a case on merit. No matter how strong the evidence, corrupt arbitrators often didn't even hear the case and simply awarded in favor of claimants based on their lawyer submissions without even considering the employer's responses. So, then we have the Department of Migrant Workers, which is a newly formed department overseeing all overseas workers. Their data shows that in the National Conciliation Mediation Board, which is the only body hearing seafarers' claims for those with CBA, for the total number, for cases that were appealed by the ship owners, 23% of those appealed were reversed or modified on appeal in favor of the ship owner. I mean, if you undertake any business or any undertaking and you have 23% chance of failing or losing, I mean, what kind of environment is that? So we now have 23%. The biggest problem, now the amount owed to the ship owner is 2.5 billion pesos. So that's 34 million US dollars from a period of 2018 to 2022 alone. So, why? What happens? When the NCMB rules, it's immediately executory. So we have to pay, even if we go on appeal. And once it's reversed on appeal, we don't see any money back. So it's just paper victory. There's really nothing there. So the ship owners continue. What happens is a phenomenon now we call settlement under duress. We don't want to go that route, even if we know the case is strong. But we know even if we win, we pay for the lawyers, there's no recovery. And what does the PNI say? Let's reduce loss prevention, reduce our liability. We settle 5 times, 10 times, 20 times, just so we avoid full disability. What are the cases we've encountered, reversed by the Supreme Court? There was a seafarer on board the vessel. He got off. 3 months on vacation, he got bitten by a rat. That's leptospirosis, he died. What did the NCMB say? Ship owner pay him $60,000 US dollars. How can, I don't have words anymore to explain to my ship owner why we're facing these kinds of judgment. Our company, we have a seafarer. So the Supreme Court reversed. The Court of Appeals reversed that case. We execute, but the money was already paid. The mining agency went after assets, there was nothing. So now, the ship owners owed $60,000 US dollars. The second one, my case. I have a crew, went on board 2 days. Some blurring on the eye. Went off. It was not work related. It happened when he was still vacationing here. So that was the decision. Yet, he went to NCMB, won, also $66,000 US dollars. We fought it. We won. Now, nothing. Nothing came out of the money. What is the scheme? These ambulance chasers normally would be in hospitals, like somewhere here, close by. They will be outside. Anything looking like a seafarer, they would approach. Have you been ill? Have you been injured? Come see us, and then I will lend you money for the meantime. While we're chasing this case, 1-2 years, we're done, then we split it. Sometimes the lawyers get 60%, 40% to the crew, or 50%, 50-50. So when we go after the seafarer, asking for the money back, the seafarer would say, I never had it in the first place. I never had it in full in the first place. So in the 2.6 billion pesos, that's 2.5, 1/2 didn't even go to the seafarers. Okay? So this is the situation we're facing now. Who are the victims? Number 1, crew. Loss of jobs, 50% reduction in market share. Refusal of owners to take crew with maintenance medication. Now we're getting very stringent with our pre-medical exam. We're afraid. We're afraid of hypertension. We're afraid of diabetes. But any 30-year-old Filipino has those conditions. So who do we hire? Right? Younger age limit. We are forced. Because then, if it's closing to retirement, they will start thinking I'll start suing because then I have something to retire on. Okay. And the ship owners, because we have a wrong concept of P&I. P&I is not your typical insurance. It is seafarers pooling their money together to as liability, as a buffer against the liability these ship owners will have. It's not a typical insurance where money is being invested somewhere else. It's not like that. It's just a bunch of people pulling money together. So if one is hurt, everybody pays off. This is what the P&I is. So at the end of the day, it's the ship owner that's paying. So what have we been doing? So one of the things is the campaign started about 2021 October. Media started to pick up the issue. This issue has landed on major newspapers. The thing is, we have asked for the escrow provision. We have a fair, equitable system in the Philippines, except in labor. Because here, unless it's final, you are not getting execution. Only when the case is final do you have to pay. But in labor, it's different. So what we have proposed, and which the unions have not opposed, is that if we have a case in NCNB or NLRC, we lose there, we immediately pay the portion that we did not dispute. The portion that we dispute, that goes on escrow deposit by the NCNB or NLRC and stays there. Whoever wins on appeal gets that money intact. That's all we ask for. We are not dodging the system because we will pay immediately the portion that is owed, that we feel was found by doctors as really being owed to the seafarers. And the other one is, of course, improve our CBAs because it's there have been some loopholes that we saw there. It's also important for our government to ensure quality decisions backed by actual evidence. They should be the one. It should be evidence-based, not allegations-based. We cannot decide in favor and issue awards in millions of pesos without even a single shred of evidence, and that is happening. The information campaign is being done. Foremost of this is the unions are actually pushing the campaigns. ITF, AMUSU. My being here is part of that info campaign. I'm also supporting this number 4, strategy. And this one, because the ship owners really do not defend so much their cases. That's also an admission on our part. We are not very strong in legal defense. That's why it has reached this stage. And that awareness has started to shift. So at the end of the day, for a country with 8.7% inflation rate, 3 million people unemployed, seafaring can contribute more to the economy and keeping the economy afloat. And we have continued to remit this amount, $6.5 billion to the Philippines, even in the midst of COVID. We are not ready to lose the jobs. I am not ready to look at my seafarers and say, sorry, no more ships. Because they have gone elsewhere. They've gone to Bangladesh, to Sri Lanka, since we're no longer viable. I am not ready to do that. That's why I'm here. So if we push, what we ask is just a fair and equitable legal system in the Philippines, where there is evidence, and improve our regulatory and strategic role, we can reclaim our previous market share. That's where I end. Thank you.
Thank you very much, Attorney Baguilat, for that presentation. We have a few minutes for questions. Any questions for Attorney Baguilat?
Yes, ma'am.
One right up here in the front, Father Bruno.
Thank you. My name is Monica Stellamaris Hamburg, and that's a question that's really resonating with me. It was really impressive and scary to see how the numbers go down. Recently on a vessel, we met a Filipino seafarers who told us, half of the Filipino crew on this vessel will be exchanged, I think he said, for Myanmar or Bangladesh. And he gave us two reasons. He said, like, they are even cheaper than we are. And we as a Filipinos, we are very polite, we don't complain. They do it even less than we do. Can you comment on that? If that is also part this whole of the whole change of the situation of hiring Filipino seafarers? I don't remember the ship owner. I'm sorry.
I'm confident Doehle has no Myanmar crew, so okay. That is competition. It's true. That happens, but then I'm also confident that our competence, because sometimes they experiment with the crew and then they go back over time. But I'm also not sure if that is really the reason, because this is not a discussion that seafarers are aware of. They are not aware of the claims being done, and what pushes ship owners are often claims. And they see the reports of the BNI every day, the losses that they are bearing. So I cannot really comment that it's just because Myanmar is cheaper. In my experience, it's because we are expensive, not because of wages. We're expensive because of the hidden cost of crew claims. That is really, we just hang our heads and cannot comment anymore because we know it's true. And this is why we're fighting back. Yes.
Another question here, Father Bruno.
Yeah, hi, my name's Kevin, I'm from New Zealand. So my question basically is, ship owners just dodging the question of welfare, when it, like in your case you're saying a major problem is actually accidents and claims. Are the companies not looking at sort of welfare issues, say 9-month-long contracts, time away from home? Maybe if they started to look at those kind of issues to better suit welfare and well-being and health and all that. For example, in New Zealand, I've shared with a couple, if you're a New Zealand seafarer, you spend 28 days at sea, 28 days back home with your family, 28 days back at sea, 28 and so on and so on. So, but they're still paid for a year's contract. So their welfare is good and the job's good and they want to stay employed rather than chase payout. So maybe my question is, do you think the companies are just missing the mark in what they're trying to, where they're trying to steer their welfare direction?
Thank you for the question. As I've said, one of our key KPIs is always safety. If we have lost time on board because we have incidents and accidents, it's a major issue. It's going to be, you know that QA will be after us because every life is valuable. So it's run across all fleets to avoid one, correct, or root cause. Why was there an accident happening? Number two, how do we correct now? Get the crew treated, But number three, prevent. Because for example, for tankers, you have high incidence of accidents, nobody will hire you. You will not get charters. So we are already that level. Our problem here is not real claims. Our problem are spurious claims. Fake claims. I just say I have a backache, no reports on board, no incident on board. They come here, I have a pain, they win. So this I cannot face. But as an industry, we're really very safety focused, and it is always a KPI of the whole ship management to ensure that we run safe ships, especially tankers. You cannot dodge that. It will be always in your record, and all your charterers will look at it if you're not careful, and that can mean you're losing out on charters. So, I hope I've answered your question. Fatigue is a huge concern, and that we are really very careful about. Work rest hours, we're cracking down on board. Don't dodge your rest hours. Internet, even it's available, but it's too prompt. People are not sleeping because they're on Netflix. So while you want them to communicate, then they're always on their Facebook or their accounts, and they're not sleeping enough. That's a concern. And we are looking at it. It's something that we look at always. But again, the problem here is not that. The problem is the fake claims.
One last question?
No question.
Thank you very much,
Thank
Attorney
you.
Baguilat, for your presentation. Sewer. Yes, small token of appreciation, so much.
Thank
Yes.
you.
Last but not least for today, we have another attorney, Attorney Dennis Gorecho, who's been our companion already for a few days this week. We've heard Father Paolo mention, I think maybe also Father John Mission mention, that his law firm, Sapalo Velez, is a close collaborator with Stella Maris in so many different ways. Attorney Gorecho was the president of the Maritime Law Association of the Philippines for 2016-17. He's on many different committees and serves in many different ways to support seafarers' welfare. So, Attorney Gorecho, we're very happy that you're with us today.
Good afternoon. Maybe some of you knew me because I've been an active participant of different ICMA conferences, Stella Maris conferences before. I'm Atty. Dennis Gorecho. I belong to Sapalo, Velez, Bundang, So when I do lectures, I usually quote this from a decision of our Supreme Court. A job of a seafarer is not exactly a walk in the park. Basically, I usually tell them, especially to the children, I tell them that your father goes to the vessel not to go for a vacation, or because he works with his sweat, he sleeps in odd hours, and when they go back, sometimes the difficulty is the children does not know them. Do not know them because of the distances. And I'm the guy on the second to the left. I'm Atty. Dennis Gorecho. I belong to Sapalo, Velez, Bundang. We've been existing for almost 50 years. We were established in 1976, and we've been servicing the seafarers for the legal front, meaning we give legal services on different forms. Aside from legal representation in the courts, I also do the lectures. I do this kind of speaking engagements in the dorms of Stella Maris. Actually, this photo was taken 2 weeks ago in the Mabini dorm of Stella Maris. And this is taken in the Popeyes. I think you will be going to this dorm on Friday. I think you'll be having lunch on the Popeyes dorm of Stella Maris. I also do lectures on the schools. Usually, I do this along with Father Paolo or other Stella Maris chaplains on the different schools all over the Philippines. So aside from the dorms, the seafarers, I give lectures on the dorms, on the schools. Imagine we have 91 schools, and I'm targeting at least 1/3 or 1/2 of those schools to be given the we call it paralegal lecture on seafarers' rights. And also I have the lectures in Calao, but right now it's suspended because of the COVID. I think the last time that ICMA had an affair here in Manila, they also went to Calao. We call it the Pambansang Tambayan of Seafarers, or the national place where they just stay, just to know each other. And this is, I also do lecture for the wives and the families. This is in Cagayan de Oro. Actually, tomorrow, I'll be flying to Cagayan de Oro. I'll be meeting them again. After more than 5 years of not seeing them, I'll be flying to Cagayan de Oro, and I'll be doing my lecture with care of Stella Maris Cagayan de Oro. So I go around the Philippines in connection with, in closing coordination with the different Stella Maris chaplains. I give the lectures. And here is ICMA in 2016. I think this is in Payus. And this is ICMA in Kaohsiung in 2019. I was also there. And I also write. I'm active in social media because we believe I believe that the best way to strengthen the rights of the seafarers is to let them know what are their rights, so they will know whenever what rights are being violated and how to enforce the rights. So I am active in social media. As you can see, I've been writing in several newspapers, so online and on the print. That's the sample of the print in Business Mirror, one of the major dailies in the Philippines. I usually write once a week. I publish my articles at the different newspapers. And I also have the social pages, the Filipino Seafarers Rights and the Pinoy Marino Rights, the pages and the groups. Whenever I give talks to seafarers, I just clarify to them what are your sources of seafarers' rights. Basically, you have the migrant law, RA 10022, and you have the PS Standard Employment Contract. But right now, I think they will call it DMW, Standard Employment Contract, because it is being devised in lieu of the creation of the DMW, the Department of Migrant Workers. The Labor Code, we have the Civil Code, we have the Constitution, and we have the International Convention recommendations like the MLC, STCW, MARPOL. So when I give lectures on seafarers' rights, I usually lift some of the lines or some of the portions of the law or the jurisprudence in relation to those laws. And what are the usual claims being given? Seafarers usually approach me with regards to these issues: illegal recruitment, illegal dismissal, non-payment or underpayment of salaries and wages, illness, injury, or disability benefits and entitlements. I usually handle all of them, but most of our clients falls under the 4 and 5. For example, illegal dismissal. Many people who are victims of illegal dismissal, they usually don't go to court. Why? Because they are afraid that if they will file cases for illegal dismissal, they will not be employed anymore. That is what we call the blacklisting. So most of the seafarers who are victims of illegal dismissal, I usually advise them that you go first out, find another employer, then you can file your case when you go back again, because you have 3 years to run after the unexpired portion of your contract. Meaning, if you get dismissed for reasons other than the authorized ones, or you have no due process, you can run after the unexpired portion of your contract. So that's illegal dismissal. The contract. Basically, when you speak of contract, it's the basic document that binds the employer and the employee. Through the principal, it goes through the manning agency. The manning agency is the agent. He is the representative here in the Philippines. So whenever there's a problem with the contract, the employee, the seafarer, can go to court and ask for a reprieve by impleading the manning agency. Because under the Philippines, we have the joint and solidary liability. The liability of the principal is attached to the manning agency if you go to court. For example, the payment of salaries. The seafarer will not go to the place where the principal is located, but he can file the case here in the Philippines because of the jurisdictional issue, the PI contract. That's why there's this policy that Filipino seafarers should not go directly to the manning agent, the principal. It should go through, should have a POA standard employment contract duly approved by the government. Because if you have a contract that's not approved by the government, you will have difficulty in enforcing your rights because you don't have jurisdiction here in the Philippines. You have to go to the place where the principal is located. And the contract is bilateral agreement between the parties. Here is the history of the contract. 1984, we had the Seaman Board. In 1984, we have the one of the first forms of the contract. Then in 1997, they released a contract. Then in 2000, they have the newest contract, which was revised in 2010. So you can see the form that we are using right now, the standard employment contract. So the seafarers, they will just input all their necessary details, and that's your contract. And most of seafarers, when I ask them, have you read the contract? The contract has two parts. The first part is this one. Usually, when I ask them, they say that, yes, I read them, but they are referring to the first page because that contains the amount of their salary, the number of months they will be on board, the principal, but they are not really concerned on the second part, the detailed part. It is the standard terms and conditions. Imagine if you have a long bond paper, 1 page, and it is divided into half. And then you also have the back page. And it contains all the details of their profession. The contract is the bilateral agreement. So all of the details are bound. They are bound by the obligation inside that contract. And they cannot question here because this is standard. What they can question is the money in the first page, not this one. So they're bound because they have the stipulations on the dismissal, on the grounds of dismissal, offenses, leave wages. So you have the details here. And it has 33 sections from the duties until the table of offenses. So many seafarers usually don't read that part of the contract because it's really small. So what we usually do, I think PIDOS, they also discuss the contract but not really in details. So what we do with Stella Maris is I go to their dorms after dinner on a weekday night. After dinner, I explain to them in a nutshell what's inside your contract. When I ask them, have you seen your contract? They will all raise their hand. When I tell them, have you read your contract? Then out of the 50, I just see less than 10. When I ask them, have you understand your contract? You'll happy if you see one hand. Meaning, many seafarers are really not knowledgeable of the contents of the contract. They are more interested in just going out, then receiving the money, than knowing their rights and obligations. So if there's a problem with their rights, sometimes it's difficult for you to explain to them, you have a problem. So here are your remedies. That's why I usually go to the different Stella Maris centers. I explain to them here. And what's the lifespan of a contract? It commences from the time when the seafarer actually departs from the Philippines. When the immigration in the airport, when the immigration stamps your contract, your seaman's book or the passport, it commences and it ends your actual arrival sa point of hire when your contract of service is terminated, signs for the ship, and arrives at the point of hire. This is critical in determining the existence of your rights. Because if your problem existed before you departed or it was diagnosed, your sickness was diagnosed after, then that will be a legal question. Because they will say that it is not part of your contract because you do not have any contract when that occurred. So those will be legal questions. And what are the medical and death benefits of the seafarers when it comes to the sources? We have the POA contract, the OWA, the Employers' Compensation Commission, and the migrant law. When a seafarer gets injured or gets ill on board the vessel, usually we refer to Section 20 of the POA contract, compensation and benefits. What does it say? The benefits will be given to the seafarer when he suffers work-related injury. You have two phrases, work-related injury and during the term of the contract. So the definition of the term of contract, I said earlier, is during the time that you actually left the Philippines and your actual arrival. So if your illness is detected after your arrival, then there will be a legal defense. Or if your illness, if you have symptoms on board the vessel but you don't have any documentation, then they can say that it is contract termination. So that's the problem with many seafarers who early, I think one of the I think sad traits of the Philippines is that they don't complain. When they are tired, usually they don't mention that they're complaining of fatigue or stress because they said that it's just stress. I'm just tired, so I just let it go. But when they go back to the Philippines, that could have been a sign of a serious illness. So if you don't have any documentation on board the vessel, that can be a problem. Why? Because you will not be able to be receiving the benefits. We have 3. Sickness allowance equivalent to 120 days of the basic wage. So maximum sickness allowance, it's like your salary, basic wage during the time that you're being treated. Second, medical treatment of the seafarer. Third, disability benefits based on the grade determined by the company designated physician. Either you are will be declared fit to work, or the grading system will be applied 1 to 14. Usually, both parties will look into 3 documentations. First is the pre-employment medical examination. It's the usually before the seafarer will go out, he will be examined by the company doctor, and he has to be truthful on his medical condition. Why? Because under the contract, if you do not tell that you have a hypertension, you have heart illnesses, you have diabetes, and you suffered from heart stroke, a heart attack or stroke inside the vessel, and they will find the medicines, that be a ground for denial. And because under the contract, there's this phrase that fraudulent misrepresentation of a pre-existing list is a ground for disqualification. And that's sometimes that's a problem with many seafarers. They don't tell that they have hypertension because they are afraid that they will not be allowed to go on board the vessel. So that's the risk. Second, illness or accident report on board the vessel. Actually, this is relevant in determining the compensability. That your illness or accident occurred during the effectivity of the contract. The best proof is that report or any medical consultation. What I usually tell seafarers that in instances that when they're complaining but they're not being given the report, sometimes that happens when your contract is about to expire. For example, you're leaving in 1 week, but during that week you're suffering from shortness of breath. I tell them, write your employers, write your manning agency, copy furnish your relatives. So what if you suffer heart attack upon your arrival, there's a documentation why on board. But many, because they say that okay, I'll just take my medicine, I'll just take my medical attention, the consultation after arrival of it, then that will be a technical defense. That they were not documented on board the vessel. Number 3 working days reportable requirement. Before you go home to Cagayan de Oro, to Cebu, or to Bohol, you have to report to your office. Why? Because you have to be endorsed to the company doctor to determine if your illness is covered. So you'll be given the benefits, and he will identify if your illness is work-related. There are 2 definitions. Work-related illness, any sickness as a result of occupational illness listed in section 32-A. Actually, later I will show the section 32-A, and work-related injury arising out of and in the course of. Actually, these provisions were implemented during the 2000 contract. Before 2000 contract, or those seafarers joining the vessel 23 years ago, when they are injured or they suffer from illness, basically they have to be paid immediately because these provisions does not exist. All is required during that time is that it occurred during the effective date of contract. There's no requirement on this aspect. So later I will show you the cases, the numbers that increased because of these provisions. So aside from the inclusion in the list of seafarers, you have 3 additional requirements that the work must involve the risk described. Letter B, that this was contracted as a result of the exposure to the risk. Letter C, contracted within a period of exposure and under such other facts necessary to contract it. And number 4, no notorious negligence on the part of the seafarer. So here, this is the list of the illnesses. That's only 22. I think that's 24. That's 24. It's just the screen is too small. That's only the 24. So if your illness is not included in the list, they will usually strike it, your claims down. For example, a seafarer who suffers from lung cancer, is it included or not? Under that listing, you only have 3 types of cancer. Number 1, actually it's on the other side, cancer of the epithelial lining of the bladder or papilloma of the bladder. Number 2, cancer, ulceration of the skin and the eyes due to certain substances, and the leukemia in number 16 and 17. So if you have lung cancer, even if you're in the company for 20 years, 15 years, you're in the vessel, in the engine, you will be denied. Because under this law, under the contract, if your disease is not included in the list, you're not entitled. And that's a short list. But the Supreme Court said, not all in the list are only the diseases, because you have the disputable presumption. Disputable presumption means that if it's under Section 20, Paragraph A-4, illnesses not listed in Section 30, the occupational list, is presumed to be work-related. Meaning, the court said that the list cannot account for all known and unknown illnesses or diseases that may be associated with, caused, or aggravated by such working conditions. So, the burden of proof should have been to the company to say that, hey, that is not work-connected. But in some of the decisions of the Supreme Court, the burden of proof shifted again to the seafarer, even if there's a Section 20-A, Paragraph A-4. So the burden of proof went again to the seafarers to prove that your illness is work-connected. That's Reyes versus Jefferson. That's a 2022 case, just last year. So how much do they decide? Actually, maybe this was already discussed in earlier. The maximum is $60,000. The minimum is $1,870, and in between, it's the division, 1 to 14. If you're fit to work, your grading will be somewhere here, fit to work, so that's 0. So you have 1 to 14. Usually, my best example is the hand. If all your fingers are cut, or it separated from your hand by an accident, you'll get $60,000 because that's 60,000. So so if your finger is cut in here actually this is an actual case we handled. If he is a cook, his finger was cut above the first line. If his finger is cut by the hole, how much? That's 6,000. But our opposing counsel said no, he has to be paid only $2,000 because you have to divide the finger into 3 based on the lines of the finger. So yeah, so if we went appeal, why don't pay him the whole $6,000? Then, if there's 2 fingers, though, if you compute it, that's 6 plus 6, that's 12. If you have 3 fingers, that's 18. But what employer will hire a seafarer with only 2 fingers? I'm not sure if someone will hire. So if you follow this tabulation, you will be given only $18,000. But there's a Supreme Court ruling that said, here, this is a grade 1, this is total permanent disability based on the POI contract, because it has a list of which are considered as grade 1. From the head, the face, the eyes, the chest, trunk, abdomen. So all parts of the body, they have corresponding grade 1 to 14. And this is a grade 1. For example, here, total blindness, both eyes, and the face, grade 1. But the court said permanent total disability does not mean that that he will be in feeble position, but it also says that the employee has can no longer earn the wages in the same kind of work or similar nature that he can. For example, the seafarer, he can no longer lift the tires or the ropes, then he can be declared as a total disabled, total permanently disabled. So that's in Seagull Maritime, and actually this is being repeated in several cases. So both parties have different interpretations. And here, for example, on ears, if your ear is a complete loss of hearing both ears, you cannot get total permanent disabled. You cannot get the 60. You can only get grade 3. That's under the contract. That's why when we argue the grading system under the contract, we say that that's not realistic. Why? Because there are provisions there that is not really realistic. How can a seafarer who lost the hearing of both ears only be given $39,000? So run after the $60,000, even if they say that that is not valid under your contract. Why? Because he can no longer go on board the vessel. Because why? How can he work if he has total hearing loss? For example, another for the eyes. Here, total blindness of one eye, grade 7. That's only, I think, $20,000. I'm not sure how can a managing agency hire a seafarer with only one eye. Give him 50% of the 60,000. That's almost 30. But can he be employed later on? No. So he can run after the 60,000. Although they're saying that you only entitled to 20,000. So the definition of the other side. That's why we go to court. We go to court because their definition is based on the contract. We, as lawyers, we seek higher benefits based on legal arguments. It's not based on the contract because the contract is really not that friendly in terms of the benefits, in terms of the compensation. So that's why we, as a court, as a lawyer, we've been in this practice for several years. We help them, although sometimes we tell them, this is your benefits under the contract. So here, that 120 to 40 days, and the benefits if he dies. Actually, for lawyers, sometimes with this was the most colorful cases that we have because of our inter-family disputes. For example, the seafarer has several families. They will fight over the benefits under the contract. $50,000 for the beneficiaries, $7,000 for each child below 21, and $1,000 beneficiaries under the law of succession. We have the succession law under the contract, under the Civil Code of the Philippines, meaning based on your closeness to the relationship of your family, you will be the $50,000 will be divided. So if you have several wives, then that will be a problem. Actually, I think Father John, Father Paulo, the other welfare officers here know the problem if there are several families, especially if the seafarer dies. They have to approach the chaplains.
We're coming up against the end of the hour, so if you can, if you have some key things to share for the last few minutes.
This is actually this is the Supreme Court cases from 1996 until 2018. So you can see the increasing number because of the issue on the work related. Actually, I was not able to get the year 2000, 2002. And actually, this is the from Professor Amante. The number of years for the case to reach the Supreme Court, it's on the average 7.2 years, almost 7 years. So I have clients that we started cases, they die before we reach the decision, or the company is already closed. So we have a paper victory. Even if we fight it in court, it's no longer available for the seafarer himself. Actually, this is the way. Actually, this is one of my favorite. Filipino seafarers file cases. The case file could not be considered unreasonable impelled by nothing but greed, but rather justified by health considerations and natural desire of every person to preserve his life for as long as possible. For being human, the seafarer should not be penalized. So that's my explanation why they are saying that why are Filipino like to litigate. That's my explanation. They want to survive. Not necessarily that being approached by lawyers to fight for the case, but for human instinct, I want to survive. I want to have better money to finance my medication. So they go to court to run after better benefits, not stated in the contract, but by law or by jurisprudence. Actually, that's almost the end, and this is the grounds for offenses under the contract that you will be sent home. Due process, first notify that you have the grounds for being dismissed, then you be given the chance to defend yourself. Then the second notice that you will have to be sent off. If you just receive the notice that you will send off without knowing the grounds and without giving the chance to defend yourself, then that is illegal dismissal. You can file a case 3 years after you are sent home. I just go. That's our branches. We have branches in Cebu near Father Mission. We have in Davao. I'm from the Makati office. We have Iloilo, and we have Cagayan de Oro. And that's my. Thank you.
Will I be allowed to share these slides with
Yes.
okay, so then you'll have his contact information. We have just a few minutes before the hour, the end of our day. Are there any questions for Attorney Gorecho? A great seminar on seafarers' legal rights. So you can be thankful if you got all your fingers, and now you know the value of your fingers and your toes. Yes.
I'll say something to Jason. Yeah. I'm Julian Islamaris from UK. I can appreciate why seafarers don't read the conditions of the contract. I myself sometimes put an insurance policy too complicated. I'll give it to my wife to plow through word for word. And if you're a rating and not highly educated, when you look at that, you just put you off. And then you will make a claim, something come along saying, oh, I can help you. You're bound to jump for it. And then another person say, supposed to be making fake claims, they consider fake claims, right? So they are on a lose and lose of a situation. So how do you help them?
For the fake claims, or when they ask questions for me, for example, the seafarers, I explain to them the grounds for example, they approach me, something happened to them. I explain to them the merits of their case. Then I tell them this is the prospect that if you file a case, either you win or lose based on what I foresee the other will raise as a defense. So sometimes, even if you're really not sure that you will win, actually I go for the case. Because I still believe that there's a chance that you will win. When you're a lawyer, you should not really stop in pursuing. That's the beauty of litigation. You can pursue a case even if it's not the best view at this moment. There will be a time that you can have a good decision. So even if from the point of view of the contract, that is not appropriate, I'd rather go for the case so I can get a good decision. So I also advise the seafarer that this is the problem, 1, 2, 3, and that will be our account. That will be a question of the merit. So even if they say that I want to win, I tell them no, you have only 50% chance to win. So they will not have false hope on the case. Did I answer your question or no?
Next,
Charles Stewart from Stella UK. Is there any gold standard contract or that will preserve seafarers from being seen off by contractors, and are they made aware of this?
The contract.
There is a good standard of contract which prevents seafarers from being swindled.
From being swindled. Actually, it's just one form. That's a standard. Actually, all they have to do is just sign the first page, and the next page are standard. So all seafarers have that same contract. They only differ on the first page. So the swindling will occur on the first page. Why? Because sometimes they are being promised for this amount, but the contract that they sign is lower. Or sometimes they receive this amount on the contract, but when they go on board, they will be forced to sign a blank document or an addendum or a secondary contract with lower amounts. So that the problem will not be on the second part of the contract, but on the first page. The amount indicated may be lower than what you have agreed, or it may be changed while on board the vessel. And most of the time they don't have the capacity to complain. When you're on board the vessel, you're just forced to sign the black document because you are afraid to be sent home. And when you go home, sometimes you don't complain because you are afraid that you will not be rehired. So the swindling occurs usually somewhere in between the signing of the contract and when you are on board the contract, when you're on board. But not on the latter part, not on the standard, because you cannot change it. That is negotiated by the government and the stakeholders. Yes, sir.
Yes, last question.
Just for clarification, what's the difference between these contracts that they're signing and these CBAs, the collective bargaining agreements?
This is the standard employment contract is the basic minimum. It's a government sanctioned contract wherein it is negotiated by the stakeholders and the government and the seafarers, the unions. The CBA is between the union and the ship owners. So the CBA differs from to ship owners and the unions. It is not the standard. So they have different rates, they have different benefits, they have different ways to address the issues of their union members. So for example, the union member of Atty, they have from the German vessels, when they die, they will be receiving $150,000. Under the pay contract, that's only 50 plus 20, something ganyan. But on the other vessels, they may get higher depending if you're an officer or a rating. It can be 200, it can be 75,000. It depends on the ship owners and you should be a union member because many Filipinos are not really union members. Some are just union members because their vessels are enrolled to the ship owners who's required to have a ship CBA. So it depends on if your vessel is enlisted with the CBA. Actually, there's also a question. Even if your CBA, you have a CBA, does not mean that you will be entitled to compensation based on the CBA, because there are some CBAs that only covers accident, not illnesses. So they have different CBAs. I think 2 years, the CBA, I think at least 2 years or 3 years. Sometimes they have 5 years. But then they negotiate the unions.
Thank you very much, Attorney Gorecho, for your presentation.